In question number 3, which asks about enumerate the rights of a copyright owner, the exact and appropriate answer to this question would be that the Copyright Act 1957 in section 14 of the Copyright Act provides copyright as the exclusive right subject to the provisions of this act. It authorizes the copyright owner for the reproduction or copying in respect of a work of any substantial part thereof, namely copyright vests in original work involving skill, labor, and judgment in respect of literary, such as books, publications, including computer, software, dramatic and musical works, artistic works, engineering, drawing, sound recordings, musical work, cinematography, films, etc. In the Indian Copyright Act, the provision is made for registration of copyright with the Copyright Office located in the Ministry of Education. New Delhi copyright registration, even though is not mandatory but optional. The registration of copyright is useful in safeguarding, protecting, and enforcing the legal rights of the owner. So, the very rights as provided under Section 14 of the Act, as we found, one is registration of copyright as provided under Section 44 of the Act and compulsory licensing as provided under Section 31 subsection 1 and the very terms of copyright as provided under Section 22. So, regarding registration of copyright as provided under Section 44, copyright may be registered with the Register of Copyright. Even though registration is not compulsory, the register will contain details like name or title of work, names and addresses of authors, publishers, and owners of copyright. Application for registration has to be made in prescribed form with prescribed fees and regarding compulsory license as provided under Section 31, subsection 1, if the owner does not grant permission for republication, performance or communication to public, Copyright Board can direct Register of Copyrights to grant compulsory license to complainant on such terms and conditions as deemed fit, as it is provided under Section 31 subsection 1 of the Act. And regarding terms of copyright as provided under Section 22 of the Act, normal term of copyright is for the lifetime of author plus 60 years from the beginning of the calendar year next following the year in which the author dies. In case of joint authorship, the author who dies last will be considered as the normal term of copyright as it is provided under section 22 of the Act. And now we'll go to the very rights of a copyright owner. So, the first right, that is rights in literary, dramatic, and musical work as provided under clause 1 to clause 6 of the Act as provided under section 14. So also rights in computer program as provided under section 14 clause B subclause 2, and also rights in cinematographic films and also rights in artistic work as provided under clause 1 to clause 4 of section 14, and rights in sound recordings, also the very right of assignment of copyright as provided under section 18 of the Act, and lastly the ownership of copyright as provided under section 17 of the Act. So, as per section 14, copyright means exclusive right to do or authorize doing any of the following acts in respect of a work, any substantial part thereof, as this right is subject to provisions of Copyright Act. So, as regarding the first one, rights in literary, dramatic, and musical work which were provided under clause 1 to clause 6 of Article 14. These rights constitutes to reproduce the work in any material form, including the storing of it in any medium by electronic means. And the second, rights in literary, dramatic, and musical work is to issue copies of work to the public. This clause does not apply to copies which are already in circulation. And the third right falling under this, to perform work in public or communicate to public, and the fourth right constituting under this clauses are to make any cinematographic films or sound recording, and the fifth one to make translation, and the sixth one is to make adaptation of the work, and the seventh one, that is relating to do in relation to translation or an adoption of work, any of the aforesaid acts mentioned in clause 1 to clause 6 of section 14 of the Act. And the second right, that is relating to rights in computer programs as provided under section 14 clause B subclause 2, and regarding that, to do any of the acts specified above in relation to literary work. And the second right falling under computer program is to sell or give on commercial rental or offer to sell or for commercial rental any copy of the computer program. However, such commercial rental does not apply in respect of computer programs where the program itself is not the essential object of the rental, as it is provided under Section 14, Clause B, subclass 2. And now we'll go to the next important rights that relating to rights in artistic work as provided under Clause 1 to Clause 4 of Section 14. So, the first rights in artistic work is to reproduce in any material form, including depiction in two dimensions from three dimensions, or vice versa. And the second one, to communicate work to public. And the third one, to issue copies of work which are not already in circulation to the public. And the fourth one is the right to include the work in any cinematographic film. And the fifth, right to make any adaptation of the work. And the sixth one is to do in relation to an adoption of work any of the acts specified in clause 1 to clause 4 as provided under section 14 of the act. And the next one is that rights in cinematographic films. So, in regards to that, the first such right is to make a copy of the film, including a photograph of any image forming part thereof. And the second right relating to cinematographic films is to sell or give on hire or offer for sale or hire any copy of the film. It does not matter whether or not such copy was sold or given or hire on earlier occasions. And the third right falling under cinematographic film is to communicate the work to public. And now we'll go to rights in sound recording. So, relating to rights in sound recording, the first one, to make any other sound recording embodying it. And the second right, to sell or give on hire or offer for sale or hire any copy of the film. It does not matter whether or not such copy was sold or given on hire on earlier occasion. And the third right falling under sound recording is to communicate the sound recording to the public. So now we'll go to the ownership of copyright as provided under section 17 of the Act. Normally, author of a work is the first owner as provided under section 17 of the Act. Author means author of literary or dramatic work, composer of musical work, artist of artistic work, person taking the photograph, the producer of cinematographic film or sound recording as provided under section 2 clause D. Right of author is subject to some limitation. And now we'll go to the provisions of section 18, which is relating to assignment of copyrights. So, regarding assignments of copyrights, the owner of copyright can assign the copyright to a work. Such assignment can be partial or full or subject to limitations. And for limited term or full term. Even rights of future work can be assigned, but the assignment becomes effective only when the work comes into existence. As some leading and popular authors sell their work at high price even before it is complete. After assignment, the assignee gets rights assigned and balance rights remain with the assigner as it is provided under Section 18 of the Copyright Act. So, in this very question regarding enumerate the rights of a copyright owner, as we found these rights are provided under Section 14 of the Act as under the heads of registration of copyright, sole show, compulsory licensing and terms of copyright. So, regarding registration of copyright, we discussed the provisions of Section 44 of the Act, and regarding compulsory licensing, we discussed the provisions of Section 31, subsection 1, and regarding the very term of copyright, we discussed the provisions of Section 22, and regarding the rights of the owner, author, or creator, producer, or any artist or publisher. We found rights in literary, dramatic, and musical work, all such rights as provided under Section 14, Clause 1 to Clause 6, and also regarding rights in computer programs as provided under Section 14, Clause B, Subclause 2, and also rights in cinematographic films, so also rights in artistic work as provided under Clause 1 to Clause 4, and also relating to rights in sound recording, so also the ownership of copyright as provided under Section 17 of the Act, and lastly we discuss about the very provisions of Section 18 relating to assignment of copyright. So this answers to this particular question would be sufficient and appropriate as to the question enumerate the rights of copyright owner. And in our next upcoming video, we'll discuss question number 4, and that is what are the civil and criminal remedies under Copyright Act. So, we'll discuss in detail the very provisions of the Copyright Amendment Act of 1994. So, the provisions relating to civil and criminal remedies as provided under the Copyright Act and the subsequent amendments in our upcoming video.